With that, I think we can just kick off by laying a little bit of the foundation for sort of what we intend to cover here. Obviously, when we think about the ethical rules, many of them make sense the most, maybe, from an outside counsel perspective, and maybe even more from a litigation perspective than a transactional perspective. But of course, we all know, you all know better than I do as an outside attorney, that in-house attorneys clearly have a need to pay really close attention to their communications and to their internal and external communication and negotiation hygiene, and that includes in a transactional context. Of course, many of you are asked to balance two roles, right? There's a legal role that many of you serve inside your organizations, but then there's also a business role as well, and then as part of that sort of multi-hat wearing role that many of you are in, you're asked to do a lot of things that sort of cross the line between legal and business work. You participate in negotiations, and you have communications with internal and external stakeholders that can implicate some of the rules that govern all of our practice, inside, outside transactional litigation, including around confidentiality, around privilege, truthfulness of disclosures, whether we can reach out to represented principals who are not themselves attorneys, all those things that we all know about and think about really, really hard for like 3 hours a year. The other sort of aspect to this presentation that we wanted to focus a little bit on, and Kara is going to be our expert here, is on the role, the increasingly common role of rep and warranty insurance in transactions and M&A transactions, which in our view really just sort of presents an additional, maybe very specific opportunity for inadvertent violations of some of these ethics rules around particularly sort of inadvertent or unauthorized disclosures of confidential information, for example. So this panel is really going to focus just on a few of the rules. You all know the rules already. There's sort of a finite set of them, but as I mentioned before, many of them make maybe the most sense viewed through the lens of an outside attorney or a litigator. So we've just picked a few that we see as presenting, maybe we will say, opportunities for inadvertent or unauthorized violations in specifically the transactional context, which obviously is why all of you are in this room rather than the other room. And then what we intend to do toward the sort of second half of the presentation is just share our thoughts on some of the best practices for avoiding some of these pitfalls, so to speak, and we would love to make this a conversation, so we welcome your input as well. All of you have been practicing, all of you are called on to sort of walk this line between business and legal functions, and if you have your own sort of thoughts or ways that you've seen this come up, or your idea about sort of best practices, we would very much welcome your input during the presentation as well. So let's make this a conversation. We would be happy to do that.
Yeah, in fact, if at any point in the presentation y'all want to come up here, I'm happy to go down there. So we can switch. So just let me know.
And I heard Mark say before, don't even bother raising your hand if that's the case. Just come up and he'll...
Yeah, I actually have Joanna picked out there. She's going to tag team in halfway through. So.
All right, so let's begin. What are the reasons why you all are even in this room? Why is this a concern? Why do we care from a transactional in-house attorney perspective about, sort of risks in the ethical context that are specific to your work? And we've highlighted a couple of the reasons here. I think they're probably obvious to many of you because you all do this day in and day out. You are participating in negotiations, you're participating in communications with principals at counterparties. But another thing that we don't often sort of talk about, but that I think about a lot as an outside attorney in the context of a deal, is that there are often experts who are involved who are also third parties, right? And to whom you are making disclosures, and maybe to whom some of your principals in your organizations are making disclosures that maybe you wouldn't always wish that they would make. Those are people like bankers and accountants and valuation experts and other folks kind of along those lines. And so I think it's important for us to begin to think about some of the hygiene that we can all sort of implement in our daily practice around making sure that we have a good handle on exactly what is happening in those communications, who's having those communications, what's being said in those communications. And then again, the second point here, you all will hear us sort of harp on throughout this presentation, this concept of sort of walking that fine line between serving a legal function and serving a business function. You all are here because I presume the vast majority of you have M&A in your portfolio at work, and if that's the case, probably many of you are serving sort of a business and strategic function. You're helping the organization that you work for grow. That may not always be a purely legal function, but you just want to always make sure that you've got a good handle on sort of when the ethics rules govern what you're doing and when the ethics rules, and I'm thinking particularly about confidentiality and attorney-client privilege, may not protect what you're doing. So how are we going to get there? What's the roadmap for this presentation? We're going to really cover these 2 points. You see them there. I'm not really like a slide reader when I'm talking. So we want to address sort of like the very most common areas where in-house attorneys, particularly in the transactional context, might sort of inadvertently run afoul of some of the rules that we're going to walk through here in the next section of the slides. And we want to, in addition to the ones that I've listed here, touch on, again, specifically sort of the sensitivities around communicating with represented principals on the other side who are not themselves attorneys. And that's just not listed there in that sub-bullet, but we will touch on that briefly later. And then, again, because we thought this concept of the communications that happen in the reps and warranties insurance underwriting process was really interesting, as if you think about it as an additional opportunity to sort of make a mistake that none of us wants to make. We're going to have a brief discussion. Kara will help us with a brief discussion of sort of the role that rep and warranty insurance plays in deals. And of course, we know that there was a session this morning, particularly on rep and warranty insurance. So the idea there is not to give you sort of a substantive rehash of how insurance works or what it does or what it's for, but instead sort of give you a sense of, in those communications, what are the underwriters expecting you to share? What are some of the ways that we think might help you sort of best protect information that you don't need to or shouldn't share in that context? And then, what are some practical sort of approaches to protecting information that because of the underwriting process is going to travel just sort of as a necessity. Of course, as we think of rep and warranty insurance, the whole point is that it helps you mitigate risk in a deal. But what we want to just sort of highlight for this crowd to think about is that it also presents an additional risk for us as attorneys from an ethical standpoint. Good so far? You all have anything? Okay. All right, so how are we going to get started? This is the foundation of our ethics presentation, which is just to give you a highlight of which rules we are going to talk about. So I'm going to run through these. I mean, we obviously started a little bit late, so I'm going to run through these sort of quickly so that we can get more then into a conversation about some of the practicalities, about the ways that this comes up sort of in real life. So you see it there, Rule 1.6. This generally imposes on attorneys a duty to safeguard information relating to their representation of a client. We will talk a little bit later on, of course we all know that. We will talk a little bit later on about inadvertent or unauthorized disclosures and exactly sort of how far attorneys need to go to sort of take the reasonable steps to protect that information to avoid those disclosures. Continuing with 1.6, well, did it go? There we go. 1.6b, this describes some of the circumstances in which it's okay for an attorney to disclose information, even without necessarily the client's sort of informed consent, like we were talking about, or like the slide before on 1.6a was kind of highlighting. But what's interesting about 1.6b is that many of the examples about where it's okay to disclose information are really extreme. And let's just all make a promise to each other in this room that things like somebody's about to get killed or somebody's going to commit like really knowing, very extreme fraud are not relevant in most of our deals on a day in and day out basis. I know that for my clients, it's not the case, and I'm aware that for the folks at the table next to me, it's not the case either. But I did want to highlight a couple of the examples in 1.6b, those are the sub-bullets here, to make one particular point, which is that these are speaking in terms of fraud, but they also talk specifically to financial injury to the other party who's receiving the incomplete or the inaccurate information as one of the ways that an attorney can violate this rule. And so I point that out because it is, I think, pretty easy for us to think about scenarios in which a misstatement or an omission could result in financial injury to a party that's on the other side of a deal. And that's a little bit different, obviously, from the very, very extreme examples like a violent crime is about to be committed, which we're not going to worry about here.
But I think the point you're making there is, if you're doing an M&A transaction, it's a $500 million deal, and you're sitting there and your client is making a comment, or you know that they're not going to make this comment that could lead to injury to the other side. If it's a $2 million, claim, is that a substantial injury that would allow you to disclose the information to prevent the fraud from occurring? Maybe not. I mean, I think so. It's a fact by fact, situation analysis.
And it's a total balancing test, right? Because
Right.
you've got to figure out where the the tension between getting the deal done and not taking on a huge unnecessary risk, right?
Right.
Continuing on, 1.6 is a really long rule. Subsection C here talks about the facts and circumstances test that courts will look to, and we probably won't have time to run into this in a great deal of detail, but that courts will look to sort of stress test whether the steps that an attorney took to safeguard information, confidential information, were sort of reasonable enough. And of course, we can think about this, even though we're sort of in the foundation setting phase of the presentation right now, we can think about this from a practical perspective because many of our organizations, certainly we on the outside as law firms, have really robust IT infrastructure built around safeguarding information. And I think to a large extent, in-house legal departments and outside law firms build out that infrastructure specifically because they think it addresses this affirmative duty that we have to safeguard information and to take steps that we view as reasonable. So, examples there, we all know them, are things like spam filters, which help protect us from phishing attempts, metadata scrubbers, which we've talked about, Mark, a couple times recently, external email warnings to let you know that something is coming from an email address that hadn't maybe emailed you before, and similarly, something that we've had for a couple years now that I hate is this prompt that lets me know every time I'm emailing some email address I hadn't emailed before and suggests a similar, which I think is actually maybe like more of a risk because it's always like, did you actually mean to email your sister? Like, no. But that is the reason, right, for some of these systems that we build up is specifically to get at this obligation that we all have as attorneys, at least on the outside, and I think in some of the larger in-house departments as well. 2.1, just continuing on with what rules we intend to cover and bring into sort of the practical focus later on. This advisor rule requires us as attorneys to use all available resources to make sound professional judgments, which really are meant to help our clients, and that includes our in-organization clients like our executives or our business teams, make really difficult business decisions. But one thing that I just think is interesting to note here is that the rule refers specifically to using not only legal information, but also other considerations, including economic considerations. And I think maybe the import here is that the rules clearly understand and anticipate and accept, I think, that attorneys will serve at times dual roles. And so certainly those of you who are in-house, it's not like you're sort of not practicing law or that the rules don't apply to you or that there's not a way to interpret the rules from your perspective. I think that the key here, maybe the tension that we should all in this room be thinking about from an in-house perspective, is how to fulfill those dual roles in a way that, again, doesn't take unnecessary risk or sort of reckless risk and doesn't jeopardize some of the protections that the rules offer your client, your organization clients as well. And that includes, around protecting privilege, for example. I think this may be the next to last rule, 4.1. This is truthfulness in statements to others. Of course, we all know we can't make false statements as attorneys of material, fact, or law to third parties. There's obviously a lot to unpack there. We probably won't get into this in a great deal of detail just because we're short on time. But we're all lawyers here, right? We can parse. I mean, I think that there are some questions here that we can begin to answer and to think about practically around what exactly is material, right? Mark, this is a point that you were making in just a moment ago. Is the statement that I'm making one of fact or is it one of law? Is there a difference between, and by the way, the answer is there is a difference between something that is sort of like a statement of opinion or something that is just sort of business positioning, along the lines of like puffery around the strength of a price, like the strength of evaluation on the one hand, and then misrepresenting or omitting an actual fact that matters that could influence the decision that a third party makes. I mean, there's a line there, and I know that the ethical rules in the courts that have interpreted them do not prohibit sort of the puffery category of statements, but certainly we all know, this is not a surprise to anybody, we're not breaking news, that they certainly prohibit lying or leaving out information that you've been asked for and that would be relevant to the third-party decision-making process that you're being asked to respond to. The other thing to sort of note here is that although there is an affirmative duty not to lie, there is no affirmative duty to just offer information that might be relevant to the third party. And so we will talk maybe a little bit later, Kara, about sort of how cute is too cute, but I'm an outside tax lawyer, so my approach is always like just answer the question that you've been asked really carefully and precisely and honestly, but I don't ramble. I mean, maybe right now I'm rambling a little bit, but I don't ramble in my disclosures, and I think that that's sort of a key distinction as well for this reason. And this, I think, yes, is the last of the sort of foundational rules. This is about communications with people who are represented by counsel on the other side of a deal. Obviously, we all know the prohibition. We're not supposed to go directly to principals on the other side of a deal when we know that they are represented by counsel. You know, from an outside perspective, outside attorney perspective, I actually run into this all the time. If I'm on the buy side of a deal, very often the executives or the business team at my client might say, oh, just reach out. I know the whoever at the other company, at the target. And on the outside, I've got to be really careful about that. And I'll always start by asking if there is an attorney on the other side. If it's a very small company, maybe there's not a GC, but maybe they've got sort of an advisor outside who's helping with the deal. I mean, I try to find that person if they're available. But, I think that there is sort of a practical approach to this too, or a question about how practical the approaches here can be. And how extreme you have to be in terms of refusing to talk to a principal or hanging up on a principal if they reach out to you and initiate the call. And so we'll talk a little bit about that and sort of how that looks in the real world, in real practice.
Yeah, I think that's tough because when you usually don't start in-house, you start out-house, right? You start at a law firm and you're really all trained up on how to deal with these types of situations and who you can talk to and not talk to. When you start to transition to, being an in-house attorney, you're kind of part of the business team or considered part of the deal team, and you don't want to be someone that is always viewed as being in the way. And that's the problem with in-house attorneys is a lot of times because of all these, silly ethical rules that we have to follow because we're attorneys, and we want to keep our license. We aren't always able to do things as efficiently as the business team would like, and so that's something that we just all have to kind of be cognizant of and think of.
All right, so this is where we start getting into a little bit more of a conversation. And again, we very much welcome all of you sort of participating in the conversation with us. But I want to turn to Kara and Mark here. Let me just sort of explain how we've thought about the rules here. We've divided them very broadly speaking into two buckets. Being careful about disclosing more than you should and being careful about disclosing, you guessed it, less than you should. So we're starting off here with not disclosing more than you should. And we want to start a little bit with sort of the contours of the confidentiality rule. Of course, we already know that lawyers are not supposed to make unauthorized or inadvertent disclosures of confidential info about their representations, particularly without the client's sort of informed consent to those disclosures unless it's necessary for some of those reasons, some of which are extreme, that we sort of mentioned before. But there is also this reasonable test. We are only sort of obligated to take reasonable measures to protect info. And so I guess one question that I sort of wanted to start with, Mark and Kara, is around what do you actually see in the real world around protecting information? We were talking about some of the IT systems that we, certainly have at the law firm. I know that your legal departments have some of those as well. I mean, what in your view is reasonable here? Yeah,
so I remember years ago when I worked at a law firm, we had a Metadac scrubber that basically would strip away all of the red lines and whatnot. And so when I went in-house, we didn't have that technology, and I was thinking of this rule and thinking about, well, how do we protect the information that may be embedded in the documents before they are sent over email to the other side? And so we ended up implementing a scrubber that essentially, we'll look at each email or each document and try to pull out the information. Everybody's familiar with them. But it's not necessarily always practical because, we have it in our legal group so that essentially I try to protect, for example, lawyers love to use track changes and they'll make changes to a document and you'll see comments, right? Well, you'll forward that to your internal client and they will immediately just send it on. And so all of a sudden, the information that you've given them, those communications that you've given them, and they're free to obviously waive that privilege, but they really didn't intend to waive that privilege. So you almost need to try to protect your client from those type of disclosures. So that's one of the reasons why we like to have those type of systems in place to protect those types of communications that may inadvertently get, separated out or sent out to the outside world. So.
And the only thing I would add is that on the insurance brokerage side of the house, all the documents, you created them. Mm-hmm. Like we didn't actually create them, so we have to rely on you for the substance of those documents. But an interesting piece of technology that we have that I think it's only because we happen to be owned by a bank, the particular broker I work for, is that I can't send any email with any attachments outside of my system without labeling that document and having to give it a security level. And then you have to go through a whole protocol in the subject line. So we typically can't inadvertently send things out.
These next two slides both deal with privilege. You'll see, I'll go ahead and advance to the second of the two slides that deals with privilege, which has a couple of cases there. We are not going to bother with a sort of case brief here. You are welcome to go and read them. I believe these slides will be available to you. Also, I think these are well-known cases. But let's just sort of touch very briefly here on, and again, I'm turning to Mark and Kara. I'm curious, in the context of a deal, when we talk about sort of who are the parties that are involved in a communication, what is the purpose of the communication, from a practical perspective, how much are you really sort of thinking through on a daily basis? Who's included on an email, for example, or is what I'm doing here legal advice, or am I crossing over into the business role? And I anticipate that you all are going to tell me, well, or Mark, maybe at least you'll tell me, it's old hat at this point. I sort of know exactly the role I'm serving, and my exec team understands what I'm doing, but I'm interested to hear your thoughts on sort of how bright a line do you try to draw when you're at the beginning of a deal for your company?
How bright of a line? So actually, it's a rather, in a way, it tends to be a blurry line. I mean, everyone knows that I'm an attorney, and that's my title, right? I'm not VP of Business Development. I'm, corporate secretary, associate general counsel. So they know that I'm an attorney. That's the role that I serve. But they also like for me to be on the deal team. And so what happens is, it's anybody that's involved in M&A, there's an investment banker on a deal, or there's a tax advisor on a deal, and they are involved in all the communications, as are you. And so they get looped in all the time. So I do have to think about, when it's time to really put my lawyer hat on and provide advice to the client, like, who's on this phone call? Who's on this email? Is there a banker on? If there's a banker on, sometimes I have to, tell them to get off. Not that I don't love you, but get off the phone. Or just allow them, hey, we're going to need some time to discuss these issues after you give your update, after you've briefed, generally the CEO or CFO or whoever it may be on the issues. We're going to break away afterwards and maybe talk things through. Again, I kind of go back to, you don't want to be the lawyer that is always, the fingers pointed at you for not getting deals done and slowing things down. So they always have to you have to kind of read the temperature in the room. You can't do that for every particular issue. You really need to think about what's really important, that you want to have these conversations outside of third parties that will destroy privilege.
Well, and that's a real tension, right? But also, you're saying read the temperature in the room. Maybe another way to think about that is, if a deal is really urgent and there's an imperative from the exec team to make things move quickly, maybe that means you've gotten an indication from your business team that that's a risk that we're willing to take because it's worth getting the deal, it's worth pushing the deal, right?
Yeah, I think it's worthy. It's not. Again, I don't know who you work for and the relationships that you have with your business team, but I think it's not a bad thing to have a conversation on, when you get on a call. Hey, do you want me on this call? And if they want you on the call, then just think about what's going to be said.
Right.
And I would just add the comment that when you get into my part of all of this with insurance, that on the reps and warranty side, pretty well everyone's a lawyer, right? The brokers are lawyers, the underwriters are lawyers, the underwriters have outside diligence counsel. Everyone's a lawyer, but none of them are your lawyer, right? And many of them aren't being a lawyer at all. I'm a lawyer, but I'm not a lawyer in that context. I'm not lawyering. So we notice that all the time, that clients seem to forget that just because there's lawyers everywhere, whose lawyers they are. And then outside the reps and warranties context, when you're just dealing with all the other insurance you may be dealing with to get these deals done, those brokers aren't necessarily lawyers at all. And then they're very confused about privilege and confidence and all of that.
And the other thing I would say that's hard for this room is that, we're all, well, maybe not all of us, but we're deal lawyers, and, we work on the transactional side. And so if you're a litigator, all of this stuff is very cut and dry. It's easy. It's clear. And frankly, the client, when you're dealing with them, they're in an adversarial relationship or situation where they're thinking about that stuff too, and they're concerned about that stuff. Client right now is just, they want the deal done. They want it signed, they want it announced, and why are you making these issues? So you really need to think about, again, back to the practical standpoint of, is it, what's going on with these communications, who's a party, and, read the room.
Right, and not let the fact that the parties may be aligned, at least in the goal of getting a deal done, sort of, blur for you the necessity of this hygiene that we're talking about, of like being careful
Right.
with your internal stakeholders about reminding them that, maybe there is a risk here, or maybe
Yeah.
it's not a great idea for me to be on a call.
And again, I think I would just, the last point on this, it's the banker. The banker is always the one that's going to destroy the privilege, because they are always the one that they are tied to, they are tied to your BD person, to the hip. I mean, they are working very closely. They have an incentive to get the deal done. They want to get their fee. And so they want to be part of every call. They want to be part of, the due diligence room. It's always going to be the banker. So think about that.
Already said we will skip this slide, but just note there are a couple of cases there if you decide to go back and do some homework later. You probably won't get credit for that.
And I love bankers, by the way, so
I used to be a banker. Okay, so this slide, it's a little bit of a misfit. We put this concept of not communicating with represented parties who are not themselves attorneys in this bucket of disclosing more than you should. I guess that's really a little bit more like making a disclosure to somebody to whom you shouldn't or something like that, but it maybe fit a little better here than in the disclosing less than you should, so that's why it's here. And we already began to touch on this just a little bit earlier, but Mark, along the same lines of the discussion that we were just having about, what is your hygiene around sort of external communications and coaching your in-house team about when you should and shouldn't be involved. I'm curious as well, what is your first step when you're getting involved in a deal and there is somebody who's not an attorney, involved there as an in-house attorney? I sort of mentioned earlier, my thing is always, is there an outside attorney? Is there an inside attorney? That's my first question. Is that how it works practically for you as well, inside?
Yeah, it's obviously, it seems silly, but you get a list of the people who are on the deal and see who the attorneys are, so you know the names when you start to see, who's invited to a particular call or a particular, meeting. But it's a real issue. It's funny, like on the way over here, we're trying to do something and a call came up and I got invited to the call, and the BD guy was like, hey, why don't you jump on this call? It'll be really helpful. There's these 4 or 5 issues. And I'm like, yeah, I would love to. But then I look on the other side, and it's just their principal and their banker. And, well, they know that I'm an attorney, and they know that I don't serve the role of business development. And this is where I think, again, it's hard for in-house attorneys because we're all, we're attorneys. We serve our clients. We want to make sure that we provide solutions. We want to get things done, and we don't want to be a problem. And it'd be easier for me to get on that call and be part of that call and maybe make some suggestions or a couple arguments and maybe be persuasive and kind of move it along instead of having to then hear the report back from the business guys and then, address it then with the lawyers on the other side. Really the way to kind of get around that, I shouldn't say get around that, but avoid that issue is to have more, kind of have the all hands calls where, their lawyers are on with their business guys and then everybody's kind of protected and represented.
So do you do real-time feedback to that team and say, hey, I can't be on the call because their attorney is on the call, and maybe next time you should think about that in advance?
Yeah, no, I do, yes, I do, without trying to shake my finger at them, but and also make it seem like I just wanted to go to lunch. So, no, seriously, it's hard for them because obviously I'm not perfect, so I get on calls sometimes where I shouldn't be on them, probably, and you find yourself invited to these situations, and then it's like all of a sudden you're like, oh my gosh, I'm on this call, and then do I hang up? Do I exit? Or is that rude? It's like, so yeah, I do try to hey, we say, is legal need to be on this call? And we try to, as we're, try not to have everything be so emergency setting that we, think about, like, should legal be on this call or not, and then make sure that the other side's on there. So everybody's getting better with it, so.
So now we can shift over to the other bucket. We've covered sort of disclosing more than you should, and also the little misfit category of disclosing to somebody to whom maybe you shouldn't. What about disclosing less than you should? Obviously the important point here is we can't make false statements, we can't omit material information that we might otherwise have a duty to disclose. And this obviously comes up the most, and certainly for me as an outside attorney, and particularly as a tax attorney, because there are often very fraught disclosures in my world, comes up in the disclosure context all the time, the deal disclosure context. And I kind of previewed, and maybe Kara, this is a place that you've got some thoughts. I've previewed my view, which is, I treat it a little bit like a deposition. I just answer exactly the question that's been asked, and I'm never dishonest, but I never offer. And you made a comment when we were talking earlier, Kara, about sort of, that line between doing what's required, answering, in as fulsome a way as you are meant to, but not being cute. I'm curious to hear a little more about what where is that line between becoming too cute?
I don't know exactly where that line is.
Right, yeah, nobody does, yeah.
I do say that we do not air the dirty laundry, the back and forth between the lawyers and all that. I mean, it's going to come down to when we're sharing with underwriters, we share the final disclosures. But my view, and this is because I'm a litigator in my background, is that it all comes out in the end. Mm. And if ultimately what you're trying to buy this insurance policy for is to transfer that risk, if you're doing something that's too cute in the underwriting process that then kills your claim later, then what have you paid for? Because they don't give you the premium back if the claim is denied. Right.
Yeah, so it's that place where threading the needle, the place where threading the needle becomes cute maybe is where you've sort of misled somebody. Even if you've answered maybe exactly precisely, it's the misleading, right? Even if it's not a false statement.
Right, it's that
not
notion
like
of
expressly false.
It's that notion of materiality, and we may all have a different view on that. But you made the comment earlier about, well, if it's a $500 million deal and it's a $2 million issue, well, it's probably below the retention. We could make an argument that nobody was going to have to pick that up anyway, right? That you retained that risk to begin with. So I think some of it is materiality is sometimes in the eye of the beholder.
Yeah. Okay, I'm going to try to keep us on track time-wise here. So, this slide is just sort of a continuation of this concept of no false statements of material fact, or, by the way, material law, although that's not what this slide is obviously covering. We might just, if that's okay, run through this to get to practical considerations. Let's sort of, how does this actually work in the real world? And again, we are well open to input. Had our first question already. If you all have thoughts about sort of what is the best practice here, we are very happy to hear them, because I think we're all in the learning phase in this room at this moment. Mark, you touched earlier on the fact that if the bankers are involved, they're always the ones who sort of blow the privilege. I mean, obviously we're talking about them because they're non-attorney third parties. In my world, if I'm brought in because there's a tax complication to a deal, very often the accountants are in the room. I just wonder if there are other examples of third-party sort of experts that you see that can complicate this issue, and maybe the underwriters are one like that. Anybody else that comes to mind in a deal context?
Yeah, I think there's what ends up happening, say for example, when we're on the buy side, we will retain all sorts of advisors to assist our business team with putting together the diligence that then we can then, pick up and give to Kara, who will then give to the underwriters. And so we will have, environmental consultants that will help us do, environmental issue, review. We will have, accountants that will help us do, quality of earnings. We'll have, tax guys that'll help us with tax. So, I mean, there could be 5 or 6 different, professionals, all professionals that, but none of them are lawyers and none of them are, your client. And so there ends up being quite a few people and so what ends up happening all the time is you'll have all these meetings with these people, and you just have to realize that, what you're saying in those meetings, whether it be diligence or whatever, that, you really want to, know that if there's something truly important, kind of raise your hand and try to talk to the client after. Have them give their reports to you, but don't necessarily have to always comment on this stuff. So
this slide is back on this concept that we've touched on a couple of times before about kind of the dual role that all of our in-house friends play between sort of a business function and a legal function. And let's just go right into, Mark, I think we'd all love to hear if you've got sort of your own, rules for yourself around, marking things privileged, not over-marking things privileged, keeping people off of communications they shouldn't be on. I mean, are there some things that you sort of try to always do, particularly at the beginning of a deal, to set the tone on that?
Yeah, I think that listen, I came from the bankruptcy world, so I always like to tell people I'm a recovering bankruptcy attorney, 7 years now, 8 years. And we did all sorts of litigation and document review, and I can remember that, there was you just look to see if there's attorney-client privilege or work product on the email, and you always look to see if there's, in-house attorneys, and that was just the easy way to move that over to the bucket of it's privilege, right? So there's, I think, in-house attorneys, there's a tendency to overstamp things with those marks. Now, but if you actually look at the case law, that's not necessarily always going to be held up to be true, right? Just because you put attorney-client privilege or work product on an email doesn't make it so. So I've actually kind of swung back the other way, which is I only use it if it truly is something important, and so it actually kind of, I think draws attention to it for my clients, my internal clients, that they know, well, this must be really important because Mark never does that, and I never uses these type of, and so that's something I actually look for, or to be careful about, is to be, precise in my communications with the client.
Mark, I'm curious, do you ever deal with the notion of, so you're buyer counsel, and then seller has counsel, but eventually you'll all be one party. Does the line start to get blurred, and who's lawyer?
Yeah, there is a bit of a blur there, but all of these attorneys out here know that can certainly be contracted to in the purchase agreement of privilege and when it transfers and doesn't transfer. But you do need to be careful in the interim period, especially you do a deal, you sign, and there's a 9-month or a 1-year closing period because of antitrust or whatever else is going on. Well, they're doing integration during that time, so they're going to start picking up the phone and calling you and asking you questions. And, well, what if they have the in-house legal team? I mean, it's just, it does become mixed, and you still always need to remember kind of where you are in the deal and, who the client is. They're not your client until you actually own the company, right? And they're an employee of the company. So, but you also need to be careful that, things can fall apart, which is where you're kind of going, in between sign and close. So, you need to be careful about talking to that business person that's on the other side that you have a great relationship with, and by the way, that you went to the closing or the signing dinner with and, played golf with or whatever. And they know that you're going to be their attorney going forward, and they're going to pick up the phone and call you and start asking you questions. Hey, we got this contract coming up and this and that. Well, they need to talk to their attorney. They're still represented by counsel. They still have in-house counsel, and it's a tough thing. That's just something to think about.
All right, so I'm actually going to, if it's okay with you both, I'm going to jump ahead a few slides. The next couple of slides are focused on in a little more detail on this concept of internal communication hygiene as well as sort of external disclosure hygiene. I think we've touched on a lot of this already. For example, I think, Mark, you've already given us some great sort of best practices around this, what this slide is attempting to cover here in terms of, marking things privileged and all that. So I think maybe we'll skip that, because what I want to do is, with the remaining time, put Kara a little bit on the spot, because we said at the top, of course, that, in our view, or at least in my view, rep and warranty insurance and the underwriting process particularly are just a very specific and additional example of a set of disclosures you've got to make and a set of communications you've got to have, sometimes with people who are not acting in a legal function like we've talked about before. And, therefore, I think they sort of introduce an additional category of risk that in a deal context that is worth, I think, talking about. So we do not want to rehash the sort of fundamental, what is rep and warranty insurance and how does it work, that we think you all had this morning. But just to level set, Kara, can you give us a sense of, in the underwriting process, what exactly is it that the insurer or the underwriter is trying to do? What are they trying to establish, so that we can then get a sense of okay, what is the context here for the necessity of the disclosures?
Right. So ultimately, reps and warranty insurance is essentially escrow replacement. So all they're really insuring is the value of the company, what you sold it as being worth in the deal. It's that simple. I mean, and so what they're trying to get at is was it the right price? Because they're insuring to that, although that's technically probably an exclusion, but nonetheless, the value of the company. So your financials, your customer contracts, could be other underlying values. So they need to see those documents that support the disclosures and the valuation. So it's really just about the money in the end. And you have to give them enough that they can actually assess that.
Now, if you are advised by a maybe much more paranoid outside attorney even than I am, would you say, as a potential insured, would you say that there maybe are benefits to just foregoing this process, maybe because of disclosure risks?
Sure.
Yeah.
I mean, I guess from that perspective. So there's a couple of things. I think one of the questions we talked about in preparing for this is what are the cons of using these insurance products? One is they cost money.
Yeah.
They do that. They theoretically put some roadblocks in the way, or not roadblocks as much as just more steps in the deal. But I think the other underlying issue that's probably important to talk about in an ethics presentation is there sort of is an implied, what we call in the insurance world, moral hazard involved when you purchase this insurance, right? So it's in the seller's interest not to give all the disclosures. It's in their interest to sell you the insurance, to sell you the company for a lot of money, and to not give all those disclosures and pass that risk off to an insurance carrier. Because once they walk away from this, all they have that they're responsible for is a portion of the retention that they may owe, right? If that.
Yeah.
So that's the con, is there's an implied sort of moral hazard in all of this. I think, though, in the end, I would say that is fully overcome by the pros, and the reason I point that out is we just know from a business perspective there's a lot of pros in this, but also the insurance carrier hires their own diligence counsel. So now there's a third party looking at this deal that has no underlying interest in what that valuation number is, right? Their job is just to get to the crux of is it supported?
So we're in the underwriting process. Information is flying around. You've got two parties, buyer and seller, that are concerned about preserving the confidentiality of information. And then you've got the lawyers who are also bound ethically to do that. I'm curious to hear a little more, if you can, Kara, about the underwriter's approach to these concerns. I mean, most deals that I work on between the buyer and seller start off with an NDA. Where can that sort of go so that we protect information the best we can in the underwriting process?
Right. So typically for us, we as the broker will sign an NDA with our client. And then once that's done, we're going to share whatever information we need to with however many carriers, 19, 20 different carriers. And those are just going to be sort of the disclosures, the sales agreement, something at a high level. And then determine which carriers are going to be the right ones that we're going to enter into a further agreement with. But for every single one of those disclosures that goes out, the carrier signs onto the NDA that we put together with our client. I think they do a good job of trying to preserve where it makes sense. I mean, the underwriters and their outside counsel, they're all sophisticated M&A counsel. The insurance underwriters aren't just your property underwriter. These are former deal lawyers themselves, so they get it. But that doesn't mean that they're not your lawyer. And then another thing I think people tend to forget about is some of these things can go beyond that deal. So an insurance carrier has certain obligations to the reinsurers. So they may need to share some of the underlying support of what they actually put up capital for. Then there's regulators that an insurance carrier may have to share some with, some state regulators, insurance regulators. And then if a claim comes, they're going to test whether that breach occurred. So now they're going to have claims counsel, they're going to have forensic accountants, they're going to have all those same experts that you would have in litigation. So the ripple effect can go pretty far.
Can I just quickly say, as a buyer, when we're acquiring a company and we have reps and warranty insurance involved, and they're at the stage of, all right, we need to engage them and start providing information, especially if you're a public company, just make sure that the NDA is in place with them before you start giving them, because it's material non-public information that you're giving, that you may be doing a deal. And so then you're giving it to outside parties. So I just make sure your NDA is in place. And once it's in place, it's, then all the other things she just talked about can happen. But I think sometimes people forget that may happen. You need a separate NDA from the one that you have with the seller.
Right. Yeah, there's things beyond just privilege we're worried about here, right?
Right, like the deal. Okay, so we get why the insurer needs to see this information and what they're going to use it for. Can you give us a sense, Kara, of what we should expect to have to disclose in the underwriting process? And I think you're going to say it's going to look a lot like the regular disclosures, right?
Yeah,
Like the
it's
document
ultimately the
disclosures,
same.
right?
It's the same disclosures. Ultimately, they're going to get access to the data room. So whatever's in there, the insurance underwriters are going to get.
And is the consequence of declining to respond to those disclosures because maybe of a confidentiality concern always that you just don't get the coverage?
You either don't get the coverage or it's more restricted. Because remember, the people who are looking at it are themselves M&A counsel, right, or M&A lawyers. They can tell that when they're not getting fulsome information, and they're either going to say, I either don't think this is supported, whatever was in the disclosure, or they're going to say, I don't have enough information to determine whether it's supported, and I'm going to restrict the coverage that I give you.
So then, Kara, I think we need some practical sort of steps around what we can do in this context. How can we protect the confidentiality of information? And I also am interested in hearing what's actually feasible in a deal. What could you get an underwriter or a broker to agree to? So, I mean, what are some of the steps we can take to protect the information?
Well, I think we've already talked about that to some degree. We sign a pretty standard NDA, and those NDAs are going to have pretty good language about non-waiver. And so most of the carriers know they're going to sign these. They expect to sign them. And then the question is just trust that they worked or not work, and things are going to leak out. But they're going to agree to pretty well we've got the slides, they're there, you can read them, but they're going to agree to all of these things.
And that also takes us to the next slide where I was going to make the same sort of comment or ask the same question. There are these other additional kind of safeguards you can take, common interest agreement. I mean, how much of this is really practical and comes up in a typical deal, in addition to sort of the NDA that we're talking about?
It's a standard process, right? So it's not like you're really negotiating what's in the NDA. They're standard, and it's not that negotiated, honestly. These are done in more than half of deals now. You're not going to surprise the insurance carrier by asking them to sign these things.
Yeah. So table stakes in a deal is what you're saying.
Absolutely.
I got it.
I think
We
Mark
are,
has a-
please.
Oh, no, I was just going to say, I'm just sitting there thinking about it is, as a buyer dealing with reps and warranty insurance, and not that you ever have to need to find an adversary on a particular deal, but you view oftentimes, not you as the broker, but you do view the underwriter as, the bad guy. And so you have to be careful about the information you provide in the diligence process and the underwriting process, because you're concerned about, well, depending on if you talk about all the bad things, or they find out about all the bad things, then that's going to be an automatic exclusion on the policy.
It's just your list of exclusions on the back
And
of the policy.
so, obviously, as on the buyer, you don't want a policy going forward that has 25 pages of exclusions. So it kind of, it's the tension that we were talking about before of, you can't lie. I mean, if the underwriter asks you a question, you need to be able to tell, but you also don't need to make them, you don't have to do the work for them. Don't, necessarily, it's not against the kind of ethical rules to, you don't have to provide a roadmap, right, for them to find an exclusion, because they're happy to find it if you give them the place to look. And so I think you just need to be careful about, and that's oftentimes why the underwriting call is especially an important one, because they have attorneys that they bring in and specialists, and they go through it, and everybody's been through this 100 times, but it's just, that's where often things can kind of fall apart sometimes, is the additional questions and supplemental questions is during that underwriting call. So, it's not quite everybody's holding their hands and, working towards it. You have to kind of remember who you're working with and against, and what their goal is versus what your goal is. It's not necessarily the same thing.
Well, and as a practical matter, you want to solicit all those questions before that call.
Yeah.
These calls can go on for hours. You don't want to just say, hey, underwriters, show up and ask me all the things. You want to have done the work to where you know what they're going to be, so you can prepare to answer them right on point.
So kind of like we previewed at the top, we are not here breaking news. We have, I think, pointed up all the tensions that you all already knew existed, and all of the sort of complications around analyzing these ethical rules that we, again, all already were aware of. This slide is just we've left a couple of minutes for questions, and we want you all to know that as much as we've identified these tensions for you, and they're tensions you've already thought about, we are not giving you legal advice. And you ought to consult your in-house attorney in a privileged way if you have questions about this, or maybe, I guess you are the in-house attorneys, and so you ought to consult your business teams. And then the last thing that I want to do is give a shout out to my associate, Macy Wagner, who helped us prepare these slides. But we did leave a couple of minutes for questions if there are any. Very happy to get more questions or hear your thoughts about best practices around any of these issues, if you have any. We were so thorough. There's not a word to be said.
They're so quiet.
Well, thank you.
Yes, thank you very much.